Good morning, everybody. You can change it.
Good morning, ladies. We'll start. Good morning, ladies and gentlemen, and welcome to the Licensing Subcommittee hearing. Councillor Marsh, Councillor Parker, and Councillor Pound are forming the subcommittee this morning, and members have nominated Councillor Parker to chair the hearing. Councillor Parker, can you please continue?
Thank you, Mr. Bowler. Good morning, everybody. Thank you for your patience. Could I ask everyone to note the fire safety instructions that on hearing the alarm you should leave the chamber via the double doors at the back exit the building through the main entrance and congregate in the car park. Also, please switch off your mobile phones and turn off any other electronic devices being used to silence. I would like to remind everyone present that this meeting is subject to an internet webcast recording where proceedings are capable of repeated viewing. If you are seated in the public area of the council chamber, it is likely that your image will be captured by the recording cameras and result in your image becoming part of the broadcast. This may infringe your human rights, and if you wish to avoid this, you should leave the public seating area of the council chamber and move to the upper public gallery. May I remind members to declare any interest when this item is raised on the agenda. Thank you. Item 2, administrative functions. Mr. Butcher is our legal representative this evening. Please can you remind the subcommittee of its administrative function and explain the procedure to be followed. Mr. Butcher.
Thank you, Chair. So I would advise members and others present for this meeting that in dealing with the business of the subcommittee, members will be exercising an administrative function, and the process is similar to that in the magistrates' court. However, the proceedings will be relatively informal, and the rules of natural justice will apply. So for the benefit of everybody that's present, I'll just outline the procedure that will be followed this morning. So Councillors Marsh, Parker and Pound are forming the subcommittee this morning. Councillor Parker has been nominated to chair the hearing, and the chair will ask all parties to introduce themselves. Then the licensing officer will then introduce the report, and members may ask questions on the report, and other parties may also ask questions if they wish. The chair will then invite the responsible authorities to address the subcommittee, and again members and other parties will have the opportunity to ask questions of them. There will then be an opportunity for other persons who have made representations to address the subcommittee, and the chair will then invite the licensee or their representative to address the subcommittee, and members may ask questions of the licensee or their representative. Other parties may also ask questions. There will then be the opportunity for the licensing manager and the responsible authorities and the licensee to make closing statements. Members will then leave the meeting to consider their decision, and they may request legal advice from me during their deliberations. When members rejoin the meeting, they will give their decision and a summary of their reasons for coming to that decision, and the decision itself will be confirmed in writing within 5 working days, and will contain the more detailed reasons for the decision. Thank you, Chair.
Thank you, Mr. Butcher. As Mr. Butcher just sorry, before I go there, are there any declarations of interest to be made? Thank you. As Mr. Butcher has outlined, at this stage, I would normally go round and ask everybody to introduce themselves. We'll do that with the officers and so on and so forth. I'm going to change this slightly because I have a list here of representation of student residents in the chambers today. So I'm going to ask if you would just indicate if you're present so I can tick this off, because I've got quite a long list here and some have attended obviously and some haven't attended. So Dale O'Shea and Jason O'Shea, are you both present? Thank you. Courtney O'Shea. Planning Authority John Morris. That would be an officer, but I would ask you to come back on that. Julie Garvin. Thank you. Elizabeth Pastel. Thank you. Margaret McKenna. David Gilbertson. Lydia Baglulu. Michael Baglulu. Thank you. Is that how you pronounce it? Sorry? Thank you. Thank you. I always get one wrong, at least one wrong. Right. Now we know who's there from the residents. Could I ask the officers starting from yourself to introduce yourself?
Jack Byrne, Environmental Health. Good morning, Dave Leonard from Birmingham Council Licensing. Paul Adams, Licensing Manager. Michael Fitch, I'm acting on behalf of Mr. Dr. Now.
Zoe Coleman, I'm on the call.
Good morning, William Butcher. I'm a solicitor. I'm acting under agency agreements with Chelmsford City Council.
I'm Jen Pound, I'm Councillor and part of the committee today.
Fiona Marshall for Councillor.
It's part of Councillor and it's my duty to chair the meeting today. We move on to the next item, which is would you introduce the matter, please?
Thank you, Chair. Good morning, everybody. This report is to determine an application received from Mr. Michael Fish on behalf of Mr. Jason Jobson for a new premises licence for White Horse 173 Oxley Glen Road, South Weald, CM14 5PX. Environmental Officer Mr. Jack Byrne and Planning Officer Mr. John Morris made representation on behalf of Cranbrook Council's responsible authorities, and 10 further representations have been received from residents living locally to the premises. All representations primarily relate to the public noise nuisance concerns, with emphasis being placed on the live music events hosted in the summer months and the antisocial behaviour of customers dispersing from the premises in the later hours. In regards to this, the background being an authorisation which is required in respect of any premises where it's intended to conduct none or more than 4 licensing licensable activities, sale of alcohol, supply of alcohol, regulated entertainment, and the provision of late night refreshment. Obviously, looking into this, the 4 licensing objectives that we've got to take into consideration today: prevention of crime and disorder, prevention of public nuisance, public safety, and protection of children and harm. So, in respect of this application, on the 8th of December 2025, an application was received from Mr. Fish on behalf of Mr. Jason Jobson for the new premises licence. A copy of the application, together with the supporting layout plans, is attached to Appendix A. The White Horse pub is situated in a semi-rural residential location and has been a fixture of Cook's Green community dating back to the 1800s. The premises has evolved quite considerably since Brentwood Council issued its first licence back in 2005, and the purpose of the application for a new licence is to update the layout plan and attach conditions more appropriate and relevant to how the venue currently operates. A copy of the current premises licence, together with a set of OS maps and images to better identify the location, is attached to Appendix B. The application is seeking to provide plays, films, live music, recorded music and performance of dance from 11 AM to 2300 hours Monday to Sunday. Late night refreshment 2300 hours to 0:30 hours Sunday to Thursday, and 2300 hours to 01:30 hours Friday and Saturday. The supply of alcohol on off premises 1100 hours to 0:00 hours Sunday to Thursday, 1100 hours to 0100 hours Friday and Saturday. I believe the applicant might be putting variation in that when he puts his application through. In addressing the promotion of the four objectives, the applicant has made the following undertakings within the operating schedule of the application that will be attached as conditions on any subsequently issued premises licence. And they would be that any event of premises over 100 persons in attendance will be risk assessed dynamically to consider the use of door supervisors. Any door supervision will be fully licensed with the SIA. Any persons refused alcohol for any reason, their name is known, or description with the time and date will be recorded at the premises. Any external provider of entertainment facilities and equipment shall ensure that the equipment has current certification in electrical safety before the entertainment can take place. And the premises licence holder will ensure that when entertainment is provided at the premises, that the noise levels shall not exceed 100 decibels within inside the premises. Further on, the premises licence holder shall ensure that there is a responsible person monitoring these noise levels and record their findings on an hourly basis during the event, and in addition to age verification for the premises. For the purchase of alcohol and other restricted items, the premises licence holder will ensure that any entertainment on the premises will be age appropriate. Further to that, licensing officer has agreed a number of conditions which are attached there. Again, should the licence be granted, those conditions are there for you to consider. In respect of representation, the Environment Health Officer, Mr. Zach Byrne, has been working with Mr. Jobson throughout the consultation period, and whilst he proposed some recommended conditions which are attached to Appendix C, he makes representation on the public usage objectives and wishes to present to be present active at the licensing committee. Mr. Byrne's representation is attached to Appendix C. A representation has also been received from Brentford Council's Planning and Enforcement Officer, Mr. John Morris, in his capacity as responsible authority. Mr. Morris has stated that the department has received complaints from residents about the presence of structures to the rear of the premises which are used by the pub for its customers and for events, and which have resulted in the succession of noise and disturbance complaints from residents. And his representation is Appendix D. 10 further representations have been received from residents living locally. Many relate to increased hours being applied for and the potential for increased public nuisance and antisocial behaviour. All representations refer to the public noises and concerns with particular emphasis being placed on the live music and outdoor events hosted in the summer months. The largest attendance capacities and the lack of sound attenuation measures being taken to address these issues occurring in the marquee and outdoor areas. Redacted copies of all these representations have been attached to Appendix B. Moving on to that, Chair, there's obviously a number of guidance from the statement of licensing policy and relevant sections from the Secretary of State's guidance, which you may wish to consider. I think that's everything we need at this stage, if I can help.
Thank you very much. Do members have any questions for the licensing officer?
No, thank you.
Is there any important notice still in force that haven't been complied with?
Not that I'm aware of, no, Mr. I'm aware that both Planning and Environment Health are in communication with the applicant, but we've not had anything served in regards to licensing.
Thank you. Are there any questions from other parties? For the licensing officer? No? We will now hear from the responsible authorities, Mr. R. Would you please take?
Thank you. So when this application was received, even before it came in and afterwards, I've been liaising with the DPS and Mr. Jobson quite frequently because we've received noise complaints throughout 2025. Some of them in the summer, majority of them in the summer, but also during the winter months as well. And it seemed as if this variation on the licence was an opportune moment to get some good noise conditions on there to hopefully create a condition where we can compromise and satisfy both the residents and the licence holder, just to make sure that whatever events they want to put on. We've got good safeguards so that we're going to mitigate noise nuisance. So I did take some issue with, which you've got my representation in the appendices of the documents, but we did take some issue with the license wording that the premises license holder will ensure that entertainment is provided in the premises that noise levels shall not exceed 100 decibels inside the premises. This is a bit of an imprecise measurement from a noise perspective. When we're talking about decibels, we kind of need a little bit more precision there, because I'm not sure if he's talking about an average level of 100 decibels or he's talking about a maximum level of 100 decibels. If he's talking about an average level, this is excessively loud, of course, but on the assumption that he's saying that that's the maximum level that it will not exceed as 100 decibels, this is kind of the noise level that we would have from a nightclub in an urban area, not a rural pub. So having said that, I have agreed informally with the license holder a maximum level of 80 decibels, which I put in the representation as well, which is much more in line with what we would expect from this, because that's not going to encompass the average. That's just going to be the maximum level we're ever going to reach, and it can't exceed that. And that's something that we've done through sound testing, and it doesn't really affect residents when we've conducted tests at that level. Having said that, there are still some other measures that I wanted in place just to make sure that we're being really robust when it comes to noise nuisance. So I've suggested that the premises licence holder shall commission a noise management plan, which report shall address the necessary measures for noise control, preventing public nuisance from noise arising from the external areas of the premises. I understand there's been some changes to what the license they do, which I think the license applicant will discuss later, but at the time that was going to include the external marquee areas, so that would, because a lot of the problems we've had is from noise from the external areas, not so much the internal areas. So I wanted to make sure that we've got a noise management plan in place that encompasses these areas so that we're, as much as we possibly can, mitigating noise nuisance, because as it stands, the building that is there, we can't get any adequate sound attenuation. It's fabric, so we can't do the usual things that we would suggest, like a noise limiter or adequate insulation in terms of having good noise insulation. The walls can't do that. So I just wanted to make sure that we've got as much as we can in terms of the noise management plan, and then again trying to control noise from the premises by making sure that customers don't use the external areas of the premises after 2200 hours, so that even though there's been an extension on the hours, and some of the residents got concerned with that as well, I wanted to make sure as well that was understood, that if you want to go outside in the external areas, that's only going to be for smoking after 2300 hours. And then beyond that, there's some more boilerplate conditions that we like for premises like this, which would be amplified music beyond background level is prohibited in the outside areas of the premises without prior permission from the Council's Environmental Health Department, which is something that we could apply for example, event notice, and then we can approve or deny ad hoc, essentially. And then finally, any music provided will be closely monitored and controlled by the in-house management team so as to minimise noise nuisance to the neighbours. I'm aware that the applicant and his team are already doing a lot of these things, but I wanted this kind of formalised so that we've got documentation so that if we get further issues, they can prove to me what they're doing, and if there's any lapses in that, we can identify where any potential issues may be. Of course, regardless of the outcome of the hearing today, this doesn't preclude environmental health from taking any further enforcement action with respect to noise nuisance. At this stage, we've not served an abatement notice, nor have we witnessed a statutory nuisance, but regardless of what is put in conditions in the licence today, we can still look into that. It doesn't mean that the residents are high and dry, so to speak, in terms of any terms of noise mitigation. We can still look at that later down the line. I think that's about it. We've had 3 unique complainants that I've been in regular contact with since about April of last year. Thank you.
Thank you. Have the members any questions?
Could I just ask about this noise management plan? I mean, is there a time limit on this? Would it come into immediate effect? How soon could you expect it to be in place?
Thank you. So what I would ask here is essentially, if this licence is granted and that condition is put on the licence, before they can have any recorded or live entertainment at the premises, that noise management plan would need to be completed, drafted and approved by my team before they can have any regulated entertainment.
You said that throughout 2025 there were a number of reflections about noise. Did you at any time during 2025 go and see the owner of the Lighthouse Public House?
Yes, so I've had a number of on-site meetings with him. We had we've done a couple of sound checks essentially. So I've gone to the premises and I said to him, look, put the music on in the marquee, have it at whatever volume that you usually have it at, and then I've had a colleague in the marquee with him to make sure that he's not tampering with the levels, and then I've gone around the neighbouring area just to see, can I hear this in people's properties? Is this a level that we think is workable? And that has been the case. Unfortunately, we've not had the chance to test it yet because there's not been any events since I've agreed that level. But I have had some meetings with them at the premises. We've discussed these complaints and what our kind of procedure is for investigating those complaints, and also to informally agree these conditions that I've put on to my representation.
Okay. What somebody chooses to set the noise at when you visit might not necessarily be the noise on the night. I take it you've never gone down on an evening or nobody's responded when somebody's complained on a night to check on the noise volume.
There have been occasions where I've agreed to do overtime with my manager, specifically to target temporary event notices that are going on at the pub. Because it's been the case that when we have a noise complaint, our standard procedure is we ask for diary sheets to be completed by complainants. We've never received diary sheets, so I don't know when people are being affected, and that makes it very difficult to proactively monitor outside of when there's a temporary event notice. So there's been a couple of occasions where I've agreed to go and do some overtime and have a look at and monitor the pub on all weekends when they've got an event on, and every single time I've done that, I've spoken to the complainant just before I've gone to drive out, and they've told me the noise levels are fine, it's absolutely okay. That's been the case sometimes because they've cancelled an event that they've got going on, or it's been because they've managed the event appropriately. Again, it's very difficult for us to be reactive to these sorts of things short notice, so I try and plan things in advance, and whenever that's happened, we've never been able to witness it. But that obviously, even if this goes ahead, I'm still able to witness it in the future if people have got concerns. That's something that we're more than prepared to do.
For the benefit of the residents that are here, is there a mechanism whereby on the evening, if they're experiencing loud music or noise, excessive noise, they consider to be excessive noise, is there a mechanism they can ring an emergency number to get somebody out to witness it at the relevant time?
Private council doesn't operate an out-of-hours noise service. That's beyond, for me to talk about. I can't help them with that, unfortunately. However, what we can do is we can proactively go and, witness it or monitor it. If I've got evidence beforehand that it's likely to go ahead. So if we've got a particular event that we think is going to cause problems, then I can say, let's agree a time and I'll come out to you. It doesn't matter what time it is, 8 o'clock, 9 o'clock, 10 o'clock, I don't mind. But in terms of reactive noise, we don't have any such service.
Thank you. I've got a few questions. To begin with, you said the difficulty with the building in containing the noise levels and so forth. Is it not possible that there is sound reduction put on the equipment, not necessarily on the building? We've done this with nightclubs before. Is that not possible in this case?
Yeah, so noise limiters are really, really good bits to get. Unfortunately, they only really work in enclosed spaces. You can't really use them in outdoor areas, which a marquee would categorise, which is why it's been so difficult to kind of try and get a level that we're happy with that isn't going to cause disturbance to residents. You're right, under normal circumstances, that would be ideal. We can't do that. We'd put it in a marquee.
Thank you. And I should know this, but I'll hold my hands up so I don't. Under normal outdoor events and so forth. I know that 28 days is, you can hold outdoor events, only 14 if it includes motor racing. In terms of the temporary events, is there a restriction on how many temporary events can be held in any particular place, or does it just go, as they're put in and decided? Under the officers,
Yes, so there is a limitation on temporary event notices for a maximum of 21 days equal to a year, a calendar year. And that is where potentially the things required. So on a temporary event notice, obviously there's a maximum capacity of 499 persons. If there is more than 10 working days notice given by the person seeking a temporary event notification, if it's not agreed upon, the only two parties that can actually make representation against the temporary event notice are the police on crime and disorder matters and environmental health and public nuisance issues. So again, Mr. Vernon said he wants to through all that. The only thing that goes with the temporary event notice, and that's specifically asked for, the temporary event notice regulates the conditions that are attached to the current licence. And the reason that we can bring that up and why the new licence needs to come into effect, if you look at page 44, which is Annex 2 of the current premises licence, when you get to condition 3, any sound or from amplified music or amplified speech will not be audible at the boundary of the nearest residential property. Quite clearly, if there's live music going on under the licence, that would breach the conditions on temporary event notice, which is how they hold their music events at the moment, assuming that the event is less than 499 people or maximum 499. That's how the temporary event notices work. And there is a limit on how many times you can do that.
Thank you. My other question is that I know in other venues where we have temporary enclosures, i.e. in this case the marquees and so forth, I get the impression that these are up 135 days a year. Is that the case, or are they only temporary, and do they come down between events, or is there a limit on them, how long they're there for?
I think there should be, that would be something that planning would do regarding a fixture, and I think Mr. Morris would probably be able to answer that one better.
It's my question basically, has there been any planning for the marquees to be there, or any time limit on how long they can be there?
They've been there for 28 days. It can be there for 28 days a year, but they've been there far longer than that. We've written to the landlord and asked them to go to a planning application by the 16th of January, and none has come in. The structure was up for a long amount of time in various phases of development. And of course, they've got no standard generation whatsoever, and effectively they're creating outdoor events that are unapproved. And there's also an Article 4 directive on the site. So all permitted development rights are removed. So any development has to be applied by a planning application. So we've sought the licensee's application, but none's come in. And that will be an opportunity for him to put forward his proposals for the site, or even consider alternative uses for the site if you want to go down that route as well. But he's not done that. So we're now having to consider planning enforcement action to get the structures removed. You said that there are events have been run without permission. They're unapproved, I think was the word you said. You might not be the person to answer this, but is that likely to invalidate any insurance they would have? Should there be an unfortunate incident?
I'm not aware of the insurance policy, but clearly it may do. There may be a permission, they may need their insurance may require them to have approval, but they haven't got any approval whatsoever. As I said, the structures were up in various phases and developments. During the summer when I went, initially they told me they were being removed, and they were advising they're taking some of them down. But when I went back, they were still up. So there's been local creepage across the car park. There are 5 marquees in all, they offer no sound stimulation whatsoever, and yet most of the events will be outside of them, whether it be weddings or music festivals or whatever. So the sound troubles across a wide flat area to the residents around it is causing quite public nuisance and disturbance and severely impacting upon the amenity of the residents in the area. So we're hoping that the landlord will submit a planning application and that can be considered. And we can possibly write conditions upon which the structures can be left only so many days of the year, or you may even want to consider more permanent structures that actually provide decent sound stimulation. Should you want to go down that route? It is a green belt location, so it is a sensitive site, and it's one that needs to go before the planning committee.
This for quite happy to be corrected, but just for the residents' information, an Article 4 directive put in by the council basically means nothing can go on a particular, on the specified area without planning permission, just so that you understand what the officer was point he was trying to make. Thank you. Sorry.
So just from the licensing perspective, obviously we are dealing with matters today under the Licence Act 2003. I'm sure your legal advisor will give you the relevant advice when you're in your deliberations, but the matter of planning, whether something has planning permission or doesn't have planning permission, is irrelevant in relation to your considerations. You cannot take that into account. If you were to make a decision based on the fact that they've got planning permission or haven't got planning permission, it would effectively weaken the decision made by the committee. So, although there is elements of planning issues at the property, it shouldn't form part of your decision today. It shouldn't influence your decision today. It's always made it clear from a licensing perspective. Thank you, Chair.
Thank you for your observations that we are consistent as a licensing committee, but we do need to take other aspects of it into consideration. I did ask if there was any enforcement on there, so back to enforcement, if it is up there, is in relationship to planning, but not in relationship to licensing. Thank you. Excuse me. Do any other parties have questions of Mr. Bennett?
Just a few questions. We're referring to licensing and playing music in the marquees, but my understanding of the licensing request is just to play music inside. So we shouldn't have any events outside. That's what their license request is, if I've understood it. We seem to talk a lot about events outside, but the license they've applied for is inside only. Is that not correct?
Thank you.
I would say, Chair, with regards to that, this is where the clarity would need what this needs clarifying with this licence. As with regards to the original application, if you look at the original licence, the plans that are on there, they're so out of date with all the temporary fixtures that have gone on. The plans that we originally had, which we actually had a copy from the police because we didn't have any in our archives, such as they are on there. The query of this is really going to be, where is the licensed area of the applicant?
Chair, I think looking at the application form, the application is indicated it is for both indoors and outdoors. So it's confusing about it. So yeah, the application for music to play inside and outside of the buildings.
Okay. Yes.
Oh, sorry. I live on Cotside Hill Road, and the White Horse Park have events, and they've started to use the field next door to me for overspill car parking. What I'd like to know is what are you going to do to monitor that for myself and other neighbours on social hours?
Yeah. Thank you for your question. It was one of my notes on, but we'll go back to the officer.
So, in terms of parking enforcement, that's not really something that I'm able to attest to. So,
alcohol involved, it's a risk to them as well. Because it's like probably a quarter of a mile down from the car. So it's about a quarter of a mile walk from the field to the pub. Yeah. So they're walking past the front of my house as well. And it's rubbish, it's noise, and which you don't want it if the licence is passed at 1 in the morning. You know, I have a young son, his bedroom is in front of the house.
Did you want to answer your question?
What I would say is that something we could probably look at through the hours of operation in terms of what's on the close. If this is still nuisance that's happening offsite, that's not really something that we can deal with at this committee. Disorderly behaviour in the street, that's generally the domain of the police. But if your concern is that they're leaving the premises late, going through the neighbourhoods and the vicinity to get to their cars and there's lots of disorderly behaviour there, that's something that I could say that could be addressed through having an earlier closing time so that doesn't happen at, as you say, early hours of the morning.
I've got a legal on it, unfortunately. But I just wanted to. I have my property, my land is right opposite. There's only one lane that separates my property from the pub car park. Now, I have various animals running along that elevation. I have out there. I have donkeys, I have chickens, I have rabbits. Although that seems very probably insignificant to people, the noise, when the noise is going, which is far louder than 80 decibels, especially in the summer, it really disturbs my animals. They all have horses as well that are up the field, that goes on to the car park, and it just impacts on my animals, which, you know, they're animals at the end of the day, and they shouldn't have to put up with all this noise late into the night as well. So I just wanted to say that.
Thank you.
All I can say to that is, unfortunately, in terms of what we can do with noise music, we can only do with the impacts of humans on animals. But I know that sounds very heartless of me to say, but that's what we're all advised to do, unfortunately.
Thank you. Governor, just for clarity, we're talking about an overflow car park on the map of 47. We have the car park obviously in the upper perimeter. Is this the area described as the field bed, or is it round in Moore's Lane?
Sorry, could you repeat that question?
Yes.
Yeah, it's next door to 275 Coxside Green Road, which is what it's not part of this field yet.
Your question, sir?
Yeah, I don't know whether I heard correctly or not. You said that you hadn't had any complaints prior to 2025 for noise, is that correct?
I believe when I checked our system this morning, the last complaint we received officially through our channels before 2025 was in 2020.
Just for the record, that is totally and utterly incorrect, because I've made numerous complaints to the council, and the council have done absolutely nothing about it. So that, just for the record, I've made a significant number of complaints over multiple years for noise.
Thank you. Are there any other questions for Mr. Dunn?
Yeah, I've got the council planning enforcement team that received numerous complaints from residents about the presence of unapproved structures at the rear of the premises. With the pub uses its customers and for events throughout the year. They were allowed to be up to 28 days a year, but they've been up for a considerably longer time than that. There were 5 marquees in all. And through using aerial photography, they've managed to identify when they've been up and when they haven't. And they haven't been up consistently. None of them have planning permission, and as I've mentioned, it's master report directive on the site. So any development, including marquees, has to be applied for. So we would unreasonably withhold an application or approval for a temporary structure on there for events. But, they've been up for a prolonged period of time, and since then we've actually, as a result of the impact of public nuisance upon residents, affecting their amenity negatively through noise and disturbance, in mid-January, we wrote to planning enforcement, wrote to the licensees asking to submit a planning application by the 16th of January. Nothing materialised. We did get one correspondence from someone on his behalf claiming that the structures have been up continuously for many, many years and thereby exempt from planning permission. That's not true at all. Aerial photography has proven categorically that is disproven. The structures have been up at various iterations and locations over that period. There is no exemption and planning approval is needed. So we basically presented the licensee an opportunity to submit a planning application, and if they go into vehicles that's going to be approved, the public will be able to make representations upon it as will councillors. And if it was approved, conditions could be required to provide damp attenuation, although that would be very difficult on the imagine within the fabric structure of a marquee, which offers little to none sound attenuation. There are many residents that live around there and are being disturbed. So there's a long history of planning enforcement on this property, and we're hoping to get some compliance here and either have the structures removed or an application submitted for their consideration. So that's where we are at the moment. Nothing's come in, so I now need to liaise with my colleagues to discuss our next steps in terms of planning enforcement.
Thank you. Thank you, Mr. Ross. Do members have other questions for Mr. Lawrence? Do any other parties have questions for Mr. Lawrence?
Yes, I do. I just want to reiterate and echo what my colleague here has said, that planning enforcement is not a consideration in this committee. I previously there was concerns there under the planning enforcement, but this is not a forum to discuss planning enforcement and planning applications.
For your observation. We will now hear from other persons present who have made representations. I have a number of residents, but I hope, or possibly, that you've already made your representations and your questions, unless you have anything else to add.
Hello, I live on Moonbird Place. I'd just like to stress there's a lot of children in the area, and the music is so loud that it keeps them up. There's also been public nuisance with glasses being thrown at fences from my neighbours. My concern is that they get the license, they haven't applied for their current licence, and they're causing a nuisance. I'm not for people having the odd event, but when it goes on so late at night, and keeps people awake, and children awake, young children, and it's causing, I think, what she's trying to stress is the green belt area. Don't really expect this in a green belt area of Brentwood. They're not, that's the truth, my concerns across really. But I don't think they're abiding by the current licensing agreements and the noises and firing excess. You shouldn't be able to hear it past the boundary. I'm past the boundary and I can definitely hear it. Yeah, it's not even slightly over, it's way over.
And also, during the summer months, I've had occasions where I've got windows open when it's very cold, and I have to turn my telly right up because of the music coming from home, which I don't think I should have to do. I wish I want to sit in my garden on a Sunday afternoon and the music is so loud and it's quite often it's really terrible music as well. It's, you know, that they don't have a good choice of live things in there. And I just think I moved to where I live for peace and quiet and like I said, to keep animals. And now we've got all this, you know, I've been there 10 years. And if he gets to extend his licensing hours, I don't know.
Question, Tom. Yeah, I've been a resident in Moores Lane, adjacent to the pub, for over 35 years. And in those 35, since Mr. Jobson took over that pub, he has shown a total and utter disregard for all of the local community. We are a close-knit community, and he has consistently run rings around Brentwood Council. So today, Mr. Jobson has demonstrated that he has not upheld any of the licensing objectives, as in clause 2.1 in the council's policies. If you grant Mr. Jobson the amended licence, what you'll be doing is rewarding him for not upholding the current licensing objectives.
Thank you. Do members have any questions of those making representation? Yeah. Excuse me. Just one question to you, because you made the observation about the noise and keeping your windows open. Is this, in your opinion, a nightly event, or is this something that you have happens when the temporary notices are given?
During the summer months, it's usually about a weekly event, the weekends. Very loud, yeah, weekly.
Thank you. We will now hear from the last two representatives of the district.
Thank you, Chair. Mr. Dobson apologised for not being here. Unfortunately, this date fell on a pre-planned trip that he had to have, so that's why he's not here in person. As he stated, the Whitehall originally taken part of the Coxside community. This application was initially driven by as we heard earlier, by the licensing authority seeking to modernise and bring up to speed the premises licence. If I just give a little thing about Mr. Dobson, he is a well-known figure in the community. He has an invested interest in the community. He has raised thousands of pounds for charitable reasons through various events held at the premises and elsewhere. This application by the applicant is to make enhancements to future-proof the licence, not necessarily to make it worse for the residents, but to future-proof it. As we know, the licence rate does struggle, and we do hear of hundreds of thousands of closures per year. Having read the representations, I noticed that it does censure on a number of noise complaints generated from the public, which I do apologise for that on behalf of them, and the events in the marquee. My final briefing with Mr. Dobson was that this will satisfy the planning, although the plan of representation, I believe, is non-relevant in this arena, is that as soon as it comes back from the script, that marquee will be coming down. So there will not be any future marquees unless it's particularly approved of in terms of application process. Having this in mind, Mr. Dobson has also offered to change the layout of the extent of the licence plan in terms of where licensable activities take place. We did circulate a list of these changes to all the interested parties to suggest that are. But if I go back to the original licence and what we're actually applying for, the existing licence is later than this current application, so it's not actually looking to extend the hours, it's looking to actually formalise them. Now, with the amendments to the plan that we circulated, if I'm taking to your bundle, on page page 45 of your bundle, which shows the original application as submitted as per the original instructions. The area in question, obviously where it says marquee, is now being disregarded. And the extent of the area for licensed activities will be in the inside of the premises, and the little area between where the marquee starts and where the building finishes. That area there, and that area is really only to hold live music events and recorded music events together with the same supply of alcohol and off the premises. Now, having spoken to Mr. Byrne briefly before this meeting, and he expressed some more concerns, that area we're quite happy to remove the playing of live music in that area whatsoever. And if Mr. Johnson does want to make an application to do it by a temporary event notice, which Mr. Byrne and his team can actually raise any objections to, should it not be. Mr. Johnson has indicated that in the future he may seek a planning application to actually enclose that area with bricks and mortar, so any noise could be reduced or kept within the building, and so not disturb any residents. Which, again, Mr. Byrne and I have agreed that should that be the case, that no events recorded or otherwise be held out there until such building or the walls have been enclosed. So we're quite happy with that, but going forward, that area will be licensed for everyone to save any bureaucracy. In terms of the application, a number of options are being put forward. Currently, and it's put in place, this is for general operating. A challenge 25 policy is in place, whereby it deals with any person who has done eating alcohol or other restricted goods over the bar. If they appear under the age of 25, they have to prove their age by appropriate means, by driving license, passport, etc. That they're over 18. There's a refusal log, which is in place. There is a staff training log, and there is an incident log in place, which, from my understanding, is now being implemented and is being applied at the premises as we speak. If I were to clarify one thing about, again, going back to the noise level, I think there might have been a misunderstanding between Mr. Byrne and Mr. Johnson as to what the noise level of 100 decibels meant is. Mr. Johnson says to himself that it would be too loud in the pub if it was 100 decibels, and so the 80 would be suitable for him as a maximum. I think he misinterpreted the meeting they had with the figures that have been said. He speaks quite nicely of Mr. Bernard about how the guidance he's given him, but obviously that my instructions came from a misunderstanding, so I want to clarify that point for you, Chairman. So, in terms of the hours of the pub, I think, as I said, they're not seeking to extend their hours late in the night, which is already in place. The existing licence has a New Year's Day till 3 a.m. From our point of view, New Year's Eve will go through until 00:30, and in fact it's a reduction of the licence per hours. In terms of recorded music, on the existing licence it's with 23:30. the new application is 2,300. So it brings it back. And again, the application is less than what he has currently got. So I just wanted to dispel that. With the police, a number of conditions have been agreed with the police regarding CCTV and other prevention of crime matters, and also there are some suggested conditions being accepted with responsible authority responsible for protection of children. I think all under 18s will be linked with premises no later than 9 o'clock. As I say, this is a community pub. It's serviced the area for many years with Mr. Watson at the helm, who is very passionate about the area. There are a lot of people from the community that use the premises and have done. They use it as a meeting point. The general operation of the premises means that it's an early trade. He doesn't have many events there other than those that are by temporary event notice within the pub, and quite infrequently the pub is almost empty come closing time, or one or two left. The bulk of the trade is the early evening when people finish work. They go there, they meet their friends, have a chat, spend a couple of hours, then go home. So, with that in mind, I would ask you to consider this application very carefully. The advice from Mr. Byrne is very valuable and very valid. However, we would, because the entertainment or the regulated entertainment is going to be kept within the bricks and mortar of the building, essentially, we don't believe that there will be any noise breakout, and so the need for a noise limiter won't be necessary with the current plan, and a drafted plan will be provided to Mr. Byrne before any event should take place as requested. So therefore, bearing that in mind, I would urge you to grant this license as amended and place whatever permissions you feel fit, except the noise limiter. If I'm giving you a little bit of background for that, if you do have entertainment that come in that are fitted with noise limiters, they tend to go away from the premises because it can damage the musical equipment if it's exceeded. And that's the difficulty of some venues controlling the entertainer itself. Thank you.
Sure, Mike. Thank you, Mr. Fish. Do members have any questions of Mr. Fish?
On page 7, 2.4, it says any event at the premises over 100 persons in attendance will be risk assessed dynamically to consider the use of door supervisors. Can you please explain that to me?
Essentially, a risk assessment would indicate that it would be a written risk assessment, but as you can imagine, the majority of persons that work at pub fulfilling is not their game, whereas a dynamic risk assessment is a physical one standing there. You assess what the information is, and you can make that assessment dynamically as to, like, we're expecting X amount of people, this and that, so we require this amount of door staff, so therefore they would order in the door staff accordingly.
So it's assessed in advance of what they expected in it. What happens if more people turn up at an event or just any occasion, but they're not expecting and they end up with more than 100 then? Is there any security at all on site?
There isn't any security on site for the executive pub, but if it's an event place, there's generally one person who is familiar with the pub, who is a SIA approved door supervisor, and he is quite often a person that's called upon should there need to be. Persons that turn up at an event that are not expected to be turned up will be turned away, and that's how the point that we refuse the job.
You said the new plan was sent to residents of Holy Races. Was any plan sent to the council for us to consider in advance?
I'm unsure as to who it got sent to. I passed it on to the licensing authority for them to distribute it to who they think should be consulted. Just to clarify, obviously there was a proposed amendment to the licence with a revised plan that was sent in. We were asked to distribute that amongst all interested parties. The majority of people rejected what was been sent, and I think that was then withdrawn by the applicant. And obviously, Mr. Fish is here today, and he's sort of suggested what his amended application is. I have actually got copies of the plan that we could provide if everybody's in agreement. Obviously, the documentation we're hearing today has to be ready for everybody to circulate that. I think it would be quite useful. But the reason it wasn't circulated in advance was it had been withdrawn.
Thank you. Any other questions of Mr. Fish?
You mentioned that as soon as the young comes back from holidays, you'll take the marquee down. Do you have a date for that?
I don't know the exact date, but the impression I got when I spoke with him yesterday was that it will be within, it's going to be days rather than weeks.
So we would be able to, if these weren't down in days or weeks, we'd be able to report that. If it hadn't come down in days or weeks, as you mentioned, the residents are allowed to report that, but they haven't obliged to what you said.
I would also, what I'll do then, Chair, at the end of this meeting is I'll contact Mr. Jobson again and get a more fixed date, and I'll pass that to the licensing authority so they've got a note of that date, obviously to the planning authority as well.
Thank you.
Yeah, Mr. Fish, just a couple of questions for clarification. So, in terms of the hours that your client has applied for, you're not proposing any change in those?
Initially, I said to bring it back to the original licence because that licence is in effect already. So there's no change with the current licence. But in terms of the application, as you can see that the hours are less than what the existing hours are if you look at the existing licence. So therefore it wouldn't be an enhancement.
Confused is with alcohol, you are looking, your application is basically to extend to midnight, and then on Friday and Saturdays to 1 a.m. Is that still the case? That's why I'm confused.
As I say, in my original application, the supply of alcohol is from Monday to Sunday, from 11 a.m. to 11 p.m., Friday and Saturday to 1 o'clock. Which, if we look at the, I'm quite happy to make that concession to bring it back into line with the existing one, to make that down to midnight, so as not to extend the licence. Is that what you're confused about?
I'm still confused. So, the original licence, the existing licence, sale of alcohol is only up to 11 p.m. Then, in your current application, at the moment, certainly on my papers, I have it as seeking to extend the hours for the sale of alcohol to midnight, Sunday to Thursday, and up to 1 a.m. Friday and Saturday. So, yeah, definitely an increase in the permitted hours for sale of alcohol. So I suppose my question to you really is that still the case, or are you? Yeah, so the existing license actually just goes up to 11 p.m. So on sale of alcohol, your client is proposing to go back to what the existing license, okay. Let me make a note of that. So late night refreshment on the existing license you don't have late night. So you'll late night refreshment, you are withdrawing that. So recorded music at the moment under the existing license, it goes up to 11:30 p.m. Sundays to Thursdays, and then 30 minutes past midnight on Friday and Saturday.
That's correct. It's really because once the sale of alcohol is finished, there's an element of that winding down period where there's still conditions entertainment being paid, but necessary to ease the customer wait. Mostly, by this time of evening, most of the clients have gone, so it's quite possible that the premises would have shut up earlier than that.
So, where I'm a bit confused, so if your current application is just to go up to 11 p.m.
You're referring to, I can see your draft document. What you submitted online is different to what you've got as your draft. I can spot the problem there. Yeah, on the bundle, yeah, you submitted it online, and what's come through online is different to what you're intending to apply for.
A moment. Yeah. Sorry. Can we, between yourself and the officers, can you actually spend the time that we are supposed to be asked to consider? Because there does seem to be a bit of an anomaly here, which you have one draft.
I just wanted to share with us if we can just very, very quickly go through the agenda pack. So from page, just want to get to it, and we can go through and agree what you're applying for, what you're not applying for. So 17 is the claims. Page 17 of the bundle. In the page notes at the bottom.
Plates can be removed. Films can be removed. Live music to remain as is. Recorded music to remain as is.
Monday to Thursday till 2300, and then Friday and Saturday to midnight. In terms of the premises remaining open, then that would be 23:30 opening, Monday to Sunday, and then 00:30 on Friday and Saturday. Does that help? It would appear that way. Yeah. Initially, the application sought to cover the whole licensed premises, and that's the boundary of the whole premises itself, including any lands or yeah, the plan was for the whole of the license. The original application was for the whole of the licensed area. However, subject to all the representations, and obviously wants to take that into consideration, the area that's marked in the orange on the plan is you have the building itself, and the orange bit outside is where the patio area is, up until where the current marquee commences. Right. Mr. Jobson's plan is in the future to actually infill those walls. I think he wants to make that more of a restaurant, foodie place. Well, obviously that's going to need necessary planning permission before he can make that. Is there any external areas? So you've got the building. You've also got the red line. Literally right. Okay. Thank you. So not this red line. Yeah, if there's any plans for an external event using that area, that will be done with use of the temporary event notice process. And again, Mr. Vernon, his team, and the police have ample opportunity to challenge that when it comes in. But it's not going to be incorporated as part of the license. I see. So it's just the internal where you're going to have regulated. Yes. Thank you.
Can I just ask?
Thank you, Chair. If I can just ask, if it's just the internal area that you're going to have regulated licensing activities, in terms of the conditions that ZAC has proposed, can I just ask what your response is to that? Would you still be looking for conditions?
I definitely still want the noise management plan. All of the other ones that I put in there still apply. We've got it's just the internal areas. This just confused me a little bit, because when I was speaking to Mr. Fish this morning, it was my understanding that part of this orange area is a patio that's not enclosed. It's not all internal. However, I've agreed with Mr. Fish that if they want any licensable activities in there in terms of recorded or live music, it needs, or the live music will be covered by a temporary event notice. But if they're not recording music in there, they first need to seek planning permission to have the walls built in so that it is fully enclosed. And then once those walls are installed, then they can use it for recording music.
Thank you, Mr. Byrne. I will come to you in a moment. I'll go to the officers first.
Just in terms of clarification, the plan that was before you today, the revised plan that was before you today, is the part of the building itself, which is in brown on the plan. The orange area must be dealt with as an outdoor space. If in the future they look to enclose that space, they'll have to do a variation to the application because to cover it from a licensing point of view. So I think we need to just be very clear that the brown area is the building, that's the internal space. If we're seeking to regulate the entertainment to extend into the orange space, that is an outside area. So that just to be very, very clear on that. Thank you.
Yeah, from a planning perspective, you think in terms of like this to show all the marquees that are currently on site. There are 5 on site at the moment, and yet it's quite confusing the plans that have been shown. So are all 5 marquees going to be removed?
It is my understanding that all the marquees are coming down. I need to see clarification on that, but I would hazard is that would be part and parcel of it as well.
Because my colleague in Brian has pointed out, the rear of the patio area is completely open. So when it's down, it travels straight out of the building. There is no rear wall in that building, so effectively it's an outside area. So really the only part of the pub that is enclosed is the brown area, that's the original part of the pub. So I mean, if they're aiming for a rear wall on this patio area to enclose it, I mean that would be totally considered lower than object. We haven't got that at the moment. Anyway, thank you.
Yeah, my understanding is that the plans that, or Mr. Dobson's plan to actually enclose that would be to have walls all around, so there would be no external, no walls that are open, just save the doors to get in and out.
I think we understand that. Just before I go to the residents, I'll go back to the manager because we had a lot of conversation on this. Have you any questions? No. Thank you.
I'm sorry, I just need to be absolutely clear. So, one, your client is effectively offering to cut right back. So it will just be that orange area of the building where your client would be seeking the license for regulated for licensable activities. And secondly, it seems to me that the only real difference between the existing license and what your client is now seeking is to extend the permitted hours for the sale of alcohol to midnight on Friday and Saturday.
That would be correct. The reason why we seek to have the outside area licensed, just the exact condition could be on it that it could be not used for such time. And I understand what the licensing authority says about having a variation later. It was looking to just try and avoid that bureaucracy a little further down the line.
And I guess from environmental health standpoint, you would not be seeking a condition relating to the external area because that's no longer going to be used.
So essentially, yeah, that patio area in the orange, if you want that license, then we're going to, as my colleague in the license said, we have to treat that as an outdoor area, and if we're seeking that at the moment, then all of our conditions still apply. However, when they do get it internal, then we can treat that as an internal error, which is going to be much better for noise control.
As Mr. Adams, obviously we have deregulation locally, so there are people who want to say a little bit about that.
Yeah, so effectively, any area that is licensed for the sale of alcohol, the conditions that relate to regulated entertainment, like musical recorded music, won't actually take effect until after the exemptions that exist kick in. So what that means, actually, any regulated entertainment up until 11 p.m. at night would not be subject to any of the conditions that Environmental Health is seeking to imply today. It's only after 11 o'clock at night will those conditions kick in for the area. So effectively, what is the brown and the orange area on the revised plans, the conditions will only kick in after 11 o'clock at night. So up to 11 o'clock at night, they can do it without complying with those conditions. From 11 o'clock at night, they would then need to comply with those conditions.
Sure. Are your questions?
So can I just ask, the pub currently, the area that you're proposing, would never ever be able to hold 100 people. So this is the application you're putting in for. Where are you proposing to put all these extra people when they come to these events?
Sorry, let me just explain. The mic's on and off because because it's being recorded, they actually go to where the mic is on, so that so when the next person speaks, you need to.
Hang on, just a moment. You put a Facebook post out last October, actually actively getting people to book your amazing venue for weddings, christenings, work parties. Is this going to be taken into the 2 NARC events that you're proposing every month, or are these in addition to that?
Okay, I wasn't aware of because I've been working with the premises. I'm not fully aware of what was put on any Facebook or any other social media. Obviously, that I could probably say that advert was in conjunction with what the planning authority has suggested with the marquees. As the marquees are coming down, I don't think there's any appetite to have them back up again. So in that terms of those type of events, it's not intended to have those sort of things. If the events are considered, again, they will fall back into the temporary event notice, which Mr. Byrne and the police can have control to change those events. In respect of 100 people, yes, it will be a push for the 100, but it's easy to set 100 people as a round figure. I don't think I've ever been able to have that many people in the general operation of the premises.
Just to clarify this point, there's got 100 people down there, but in terms of the premises, whatever those premises may be, whether it's with the extension or without the extension, it will be up to the environmental officers to decide whether the venue can take X number of people. So there will be restrictions or non-restrictions according to the amount of room that is decided. They've got 100 down there. I've got no idea whether it can take 100 or it can take 150 or only 25, but environmental will obviously take that into consideration when they come through.
This comes back to the point that when these events are over weekends, by the time the event's been and gone, it's caused a lot of distress to local residents and it's too late. No restrictions being put in place, so.
Sure, if I could answer that. As I said, the events that you're suggesting, the big parties or things like that, or festivals, these are now going to be done under the legislation, licensing legislation, as a temporary event notice. And so therefore, there will be advance notice to the authorities of this event before that event goes on. So there's an element of protection to you as the residents.
Again, just for clarification, if you're not aware, every week or every month, we have applications for temporary licenses. This is in case I'm not sure if you're aware how this works, but authority, and it's up to them to grant or not grant that application. So we have several every week or every month that come through from schools, parish councils and so forth. So the temporary event would come under that jurisdiction. It would either be given or not given according to what the licensing authority thinks is applicable. You wanted a question, sir?
When I spoke earlier, I said that Mr. Jobson and his representatives have consistently run rings around Brentwood Council. This is exactly what is happening once again this morning. I must urge the committee to adjourn this because we haven't even seen this until it's handed down this morning. We haven't even seen this amended application. We're the residents. I'm living directly next door to that pub. And once again, we are running around trying to slip an application in, and it's just not acceptable. It should be adjourned so that everyone can take the relevant legal advice.
Just put your mind at rest. The application that is in front of us is actually relevant. The reference to the enclosed space is not relevant because it doesn't exist, and we will not be looking at that as an application in the future. Unless my legal representative wants put me under a different line. This has been put forward, but it's not part of the application. It's not something that we're sitting here to decide on. We're sitting here to decide on the application. The public representative is quite in order to remove some of the times and so forth, as long as it's not increasing them, because that would be a problem, because, like you say, you've not been notified and so on and so forth. Increasing is quite relevant to this committee. You've taken into account what the applicant or the applicant's representative is saying in regards to amending the application, which, in my mind, could be beneficial. It's not detrimental because we're not asking to increase. We're asking to look at going back to more or less the original application that stands at this moment in time. So I take your point, sir, but we're not looking at something that's not there. We're only looking at something that applies at this moment in time. Should, in a later date, the applications for planning or alterations to the licensing, that will either come before us or go before the licensing officers, and that will be dealt on as a separate case. The planning application has got nothing to do with this committee. It's something that's in the future, and if it happens, then it's up to the officers to decide whether they can survey the hole in that extra area, or whether they can use it to X number of people. Totally different to what we're sitting here to do now. So I take the point that you think we're being turned over to a certain extent, but in this particular instance, we're only going on what we've already seen and what already applies. Okay.
Yeah, just what the chair has said is absolutely correct from a legal standpoint. So it's not increasing the application at all. It's actually what's being offered up is a significant reduction in what is being applied for. The one issue or point that I would identify, and the only difference now, is that the applicant is wanting to be able to sell alcohol from 11 p.m. to midnight on Friday and Saturdays. That was already, already applied for. That is cutting back on what was originally applied for. So that is really the only issue everything else, it's fair to say the applicant has effectively withdrawn. In terms of planning, yes, planning enforcement is not relevant. It doesn't fall within the remit of this subcommittee. Planning have given evidence about noise nuisance, which is relevant, but in terms of unauthorised structures, that is a completely separate statutory regime. So, planning enforcement, rightly or wrongly, is not something that this subcommittee can take into account. If it did take it into account, then its decision would be liable to legal challenge. So that has to be the advice that I give the chair and the other members of the subcommittee. I just have one other query which I'm going to address to Mr. Fish, is that your client already has an existing premises licence, as we know. Now, I am assuming that if the committee, and it's not for me to preempt the committee's decision, if the committee were to grant this licence as amended, I would be assuming that your client would surrender the existing licence.
Yeah, we don't have the opportunity. If a licence is granted today, then the existing licence will be surrendered.
Yes, thank you, that's helpful.
Yeah, that's a pleasure. Are there any other questions from other parties, please? Before we're required to consider the matter, there is an opportunity for you to make closing remarks. Mr. Leather, have you anything to add from the licensing authority?
No, Chair, I'm just glad that everything has been clarified today. That was, I think, the whole purpose of the application in the first place. Thank you.
Thank you. Mr. Byrne?
Nothing more from me, thank you.
Mr. Morris, do you have anything to add?
Nothing more from me, thank you.
Okay. Does other persons have anything to say? Thank you. Mr. Fish, have you anything to add?
Nothing further from you, Chair.
Thank you very much. We will retire and consider our decision. I will ask Mr. Butcher, our legal advisor, Mrs. Bowman, our clerk, to join us to help with the wording of our decision. Thank you for your time, and perhaps you'll be patient until we come back. Thank you. Thank you everybody for being so patient. I'm sorry that it's took so long. I will now ask Mr. Butcher, our legal representative, to read out our decision and how we arrived at it. Thank you.
Thank you, Chair. So I'm going to read out the decision, but there will be a more detailed a decision notice that will be sent out, which will be more detailed in terms of amplifying on the reasons for the decision. So the decision is that the subcommittee has decided that the application, which has been substantially amended by the applicant, when I say substantially, that is definitely the case, has been cut back both in terms of the extent of the application site, so it just refers to the building itself, but also in terms of the licensable activities that have been sought. So it's now, in effect, just seeking an extension of the permitted hours for the sale of alcohol from 11 p.m. to midnight on Friday and Saturday to be granted. This grant is subject to the mandatory conditions and the conditions that have been proposed by the police, and also the conditions that have been proposed by environmental health. It's also subject to conditions. The precise wording will follow in the decision letter, but conditions along the lines that before the licence comes into operation, the applicant liaise with and produce a plan to be approved by the licensing team, which makes it absolutely clear as to the extent of the premises. The licence also not to come into force unless and until the applicant has surrendered the existing 2012 licence. It's fair to say that the committee is disappointed at what were in effect last-minute changes, last-minute cutbacks to what was applied for. Nevertheless, the applicant is not applying for more than what was originally sought. The amendments are all reductions, and therefore, from the legal standpoint, that is permissible. Detailed reasons will be given for this decision, but the committee on balance has taken the view that it's appropriate for the promotion of the licensing objectives that the application as amended be granted. One of the reasons for this, among other things, are that the new licence will be limited to the building itself, and it will have the benefit of modern conditions, which will certainly enable the council to have more control. Conditions sought by environmental health and police. The position regarding the application of the existing licence to the external areas will have been clarified, and recorded music has been cut back from 11:30 p.m. to 11 p.m. under the new licence. Events in the external areas, if they are carried on, can only be carried on lawfully under the grant of a temporary event notice. So, in summary, I think it's fair to say the committee considers that the grant of this licence as substantially amended will be more resident friendly. That is basically it. But as I say, there will be the detailed decision notice sent out in the post in the next, or by email in the next 5 working days. Thank you, Chair.
Thank you, Mr. Butcher. Before I close the meeting and the business today, noticed that a number of heads were shaken at the back, and I understand that I'm not sure what you expected from the committee, but the committee's feelings that by having a new licence, it takes away the treasure of the old licence, and by removing the old licence, which more or less gave permission for the use of the outdoor area within that licence, is now taken away, and the only provision is for alcohol sales and so forth within the premises itself. It doesn't alter for anybody. The possibility of temporary events being asked for, that goes, as I said before, to schools, to parish councils and so forth. That's normal. But the good thing about that is that if the temporary event is held and it's deemed to be unreasonable for the residents and so forth, when they apply for another one, environmental health or the police can ask for it not to be given. So there is much more cover in relation to the residents and for the council to make provisions for better management. I hope I've explained it, and a legal advisor has explained it as best he can. But we think that by restricting all sales of alcohol and so on and so forth within the building itself is a much better answer to what we have at the moment. Thank you all. I would like to